As it starts to get nicer out weather-wise here in Northern Virginia, it's really important that you understand that if you're out and about at a happy hour, at a dinner, at a friend's house, and you've had something to drink, it's okay to have a drink and drive. What it's not okay to do in Virginia is to be impaired. And so what that means is they either have to prove that you're a 0.08 or higher in terms of your alcohol level, or they have to show that your speech, manners, physical coordination, those type things have been affected to the point that you can't safely operate your vehicle. In order to do that, when an officer stops you, they're going to have reasonable suspicion to make that stop. It could be speeding, running a red light, being asleep at the light. It could be an accident that they're responding to. It could be weaving inside or outside your lanes. It could be no headlights. It can be a lot of different reasons. Once the officer makes that stop, and they approach the vehicle, if they smell the odor of alcohol, if they're identifying slurred speech, bloodshot eyes, you're not making sense, they see alcohol in your vehicle, or anything like that, they're going to ask you if you've been drinking. If you tell them that you have, then you've confirmed their suspicion that there's been some sort of intake of alcohol. Then they're going to ask you to step out of the vehicle to try to do some field sobriety tests. We call them standardized field sobriety tests. There's 3 that are standardized and have certain criteria that are supposed to be met in terms of having you perform those tests, and on how you actually perform and what things you're kind of being assessed on during those tests. It's important to understand that you do not have to answer the officer's questions except for handing them your license, and cooperating with any other requests that they make. If they require that you step out of the vehicle or anything like that, you should cooperate and let your attorney deal with it later. You don't want to fight, you don't want to argue, you want to remain silent, hand over your license. You can say you want to remain silent until you speak to an attorney. You have the right to do that. They don't often advise you of that until way later, if at all, but you do have that right. If you do get out of the vehicle, you do have a right to take the field sobriety test, but you are not required to. Some officers will tell you that you don't have to. Others make it feel like, or make it seem like, that you have to complete those tests. You have to understand that when you're doing those tests, they're looking for every little bad thing that you're doing. They're not looking for the good things. They're not looking for you to pass them. They're usually looking for the bad things in those tests. So they're going to use all of that against you in order to make an arrest for the DUI or DWI. At the end of those field sobriety tests, they may say, okay, I want to confirm whether or not I think you're safe to drive. Would you like to blow into this preliminary breath test? It's called a PBT. It's a little handheld machine that they use to have you blow into on the side of the road so the officers can determine if they think you're safe to drive. You have the absolute right to refuse that test. They're supposed to read to you from a card, or oftentimes it's from memory, that you have the right to refuse it, that it can't be used against you in court unless your attorney challenges probable cause. That's a pretty big important factor there. Some of them read those things properly and some of them don't. There is case law that says if it's not read to you properly, it doesn't necessarily mean that it can't come in, but that's something that's left open for your attorney to challenge. I always recommend to my clients and friends and family that they don't take those field sobriety tests and that they don't blow into that preliminary breath test there on the side of the road. If an officer arrests you after that, then they're going to take you to the station. They're going to swear out a warrant for you after they've taken you to try to do a breath or a blood test. They're either going to have you do blood if they think it's a DUID, which is a driving under the influence of drugs, or if you have medical issues, or if you weren't able to blow into the machine, they can take you to have blood done. They can get a search warrant to have a blood warrant drawn if they'd like to. So if you refuse to take a breath or blood test, they can get the search warrant, or you're going to have the breath test done. That gives you 2 chances to blow into it. It has to be within 0.02 of one another, and then they drop the highest one and they use the lowest number that you blew, and they drop the 3rd digit off. So if it's like a 0.089, they're going to make it a 0.08. You're going to get a carbon copy paper that shows exactly what your blood alcohol level was. When they take you to the magistrate and the magistrate issues that warrant, it's going to be for a DWI or a DUI. It's driving while intoxicated if you're a 0.08 or higher, or driving under the influence if it's under that 0.08, or if it's a blood case where they don't really know what your blood alcohol may be because they don't have the blood results yet. There's a lot of different issues that go into DUI cases, both for breath test cases, and then there's separate issues for blood cases. it's really, really important that you talk to an attorney as soon as you've been charged so that your attorney can start working on your case. Sometimes there's an administrative hearing that we can file dealing with your license, which gives us a chance to get some information on your case and maybe try to get your license back sooner than the 7 days or even the 60 days or longer that it could be suspended, depending on if it's a first, second, or subsequent offense. So make sure you hire an attorney, understand your rights, understand what penalties you're facing. For instance, if you're found guilty of the DUI and you're a .15 or higher, that requires mandatory jail time in Virginia. Virginia right now requires ignition interlock installed on your vehicle if you want to have a restricted license, which a lot of people in Northern Virginia need to get to work, to medical appointments, to the probation office at ASAP to make sure they take the classes and treatment that ASAP requires them to take. So you need to make sure that you examine all the medical issues with your attorney, the legal issues, the facts of the case, and give your attorney all the information that you have so they can figure out what issues are present in your case, and then they can prepare for trial or possibly an agreement if it gets to that point. Make sure that you ask your attorney the questions on what they think your chances could be based on the facts that they're seeing. You got to remember too, it doesn't just come from your side of things, it also comes from the officer's perspective. There's video in a lot of these cases now, and sometimes body cameras, and then there's police reports oftentimes. So we're going to get all of that information and try to organize it in a way that we can talk to you about it and tell you, okay, I think you've got some issues here, or you know what, this is going to be a tough one, but here's where I think we might have the issue in your case. And we'll go over all of those issues with you, answer all of your questions, and make sure that you're prepared